Case number 113675, Central Kansas Medical Center, DBA St. Rose Ambulatory and Surgery Center, v. Stanley M. Hattasol, MD, et al.
May it please the Court, Mr. Chief Justice, KJ Wall appears on behalf of the petitioners, Great Bend Regional Hospital, and Central Kansas Family Practice. I'd like to, if the Court so inclined, reserve 3 minutes for rebuttal. Chief
3
Justice.
minutes is granted.
Thank you, and I'm going to do my best to split my time equally with counsel for Dr. Hattasol as well. So around the 6-minute mark, I'll try and wrap up and cede the remainder of our direct time. By way of background, this case originates from Barton County, and it arises from an employment contract between Dr. Hattasol and Central Kansas Medical Center, or CKMC. Dr. Hattasol subsequently left the employment of CKMC and joined Great Bend Regional Hospital. In turn, the former employer, CKMC, sued under the non-compete provision of that employment contract and joined our client's Great Bend Regional Hospital under a tortious interference with contract theory. Ultimately, the district court found that that contract was unenforceable and violated the corporate practice of medicine doctrine under the precedent of this court in Early Detection Center. The Court of Appeals reversed that, and in doing so, and into my argument, committed legal error by applying an expanded, extrapolated version of this court's holding in Weiss, when under the facts of this case, Early Detection Center really does control the outcome of the proceeding. And the reason why has a lot to do with the corporate organization and structure of CKMC itself. As the Court of Appeals recognized that CKMC isn't really an ambulatory surgery center, it's a former hospital that's comprised of 8 separate independent divisions that are providing medical services to the community. One of those divisions does contain a same-day surgery center. However, Dr. Hattasol was employed to provide family medicine services at an unrelated clinic for an unrelated division. It had nothing to do with the ambulatory surgery center or the license that that surgery center held. And absent any sort of nexus between Dr. Hattasol's professional services or the contract and that licensed ambulatory surgery center, what are we left with? Nothing but a general corporation, CKMC, that employed Dr. Hattasol to practice medicine. And those facts are no different than Early Detection Center. And it's a violation of the corporate practice of medicine.
Where does that doctrine come from?
Well, it originated in common law, but I think over...
Well, it's a judicially created rule, right?
Correct. That's correct.
What is it about the judicial power that allows a court to engage in the regulation of occupations like that? I mean, I'm questioning really the validity of the corporate practice of medicine doctrine from the get-go.
Gotcha. I can't explain. There was obviously a public interest motivation behind it. Where the authority itself comes from, I'm not sure. Fortunately, that doctrine is now inextricably intertwined with legislative enactment.
Is that true in this case? In other words, if that doctrine goes away, is there anything in statute that would prohibit the enforcement of this contract?
Yes.
What is that?
Under the Kansas Healing Arts Act, individuals cannot practice medicine without a license.
But that's not the claim here, is that an individual was practicing without a license, is it?
Right. I should say that only an individual that is licensed can practice medicine. And in this context...
A corporation isn't a person here?
Correct. That's exactly right.
In contrast to some other law.
Well,
right. But by directing and controlling the agents, it is, in effect, practicing medicine. And there are provisions within the Kansas Healing Arts Act that carve out limited exceptions to the corporate practice of medicine for teaching hospitals,
right.
teaching schools.
But I guess my question is more broad than that, which is I'm looking for a place in statute where the legislature has codified the ban on corporate practice of medicine that was judicially created, and I don't see it.
Yeah,
It just is silent on
you're
that.
not, there is no statute that codifies it directly, but what
So
it
nothing in
does,
statute says that this arrangement is illegal. It talks about other arrangements that are specifically codified as being legal, but it doesn't, I can't find anything in
Yeah.
statute that would
Yeah.
prohibit this.
it's a common law doctrine that the legislature had the opportunity to overwrite, but did not. Instead, worked around it because it's necessary to have a comprehensive regulatory scheme.
But for you to prevail, you have to have as the baseline that common law rule. Without that baseline, it's like, the whole rug's being pulled out from under you. Isn't that right?
I don't know that the whole rug is, I just don't know how you can give effect to those statutory schemes, the Professional Corporation Act or the provisions of the Kansas Healing Arts Act, and do away with the doctrine entirely, because they implicitly endorse
They might be rendered somewhat superfluous. I could understand that argument. Is that what you're saying?
Yes, yes. And I think that the court would want to construe the legislative enactments in a way that would give them meaning.
It's
I
more
thought
than
I-
superfluous, though, isn't it? Because didn't you say they legislated around them? They legislated with the assumption that the doctrine was in place, in other words.
Correct.
Legislated and regulated with the assumption that the doctrine was in place.
Correct.
So isn't it your argument that the design of the statutory and regulatory environment was affected by the assumption that that doctrine was solid?
Yes,
Okay.
yes. That
So it's
is-
more than superfluous. It's not just that those statutes and regulations, some of them might be rendered superfluous. It also communicates something about the assumption of the legislature in doing the legislating it did.
Absolutely.
Okay.
Absolutely.
And maybe I missed something here because I thought you started with the premise that only licensed individuals could practice, even if we accept corporation as an individual. The only mechanism for a corporation to be licensed is under the hospital licensing statutes. Isn't that correct?
Well, a general corporation,
Right.
correct. The Professional Corporation Act, however, allows a professional corporation to practice medicine. And the reason why that is allowed, because then it does become a licensee by de facto, and has to get approval through the Kansas State Board of Healing Arts. And then they have jurisdiction over the entity and the individual practitioners. So it's that regulatory safeguard that Professional Corporation Act reinforces part of this regulatory scheme designed to protect the public. The problem, I think, with the Court of Appeals argument is that you unwind this perfect fabric of protection for the public between the corporate practice of medicine, KDHE regulation, and the Kansas State Board of Healing Arts. Because here you have a hospital that could have been fully regulated in every aspect by KDHE. When they abandoned that license and focused only on one division, a surgery center, that's the scope of KDHE's review, control, and jurisdiction over this entity. It doesn't have authority to regulate these other 7 divisions. So it's up to the Kansas Board of Healing Arts. Well, the Kansas Board of Healing Arts cannot regulate and exercise its full authority over a general corporation that's not a licensee, which is the very reason the Professional Corporation Act exists. Will allow a professional entity to practice medicine
Well, it
because that
could.
brings it into the
If
jurisdiction.
we didn't have the judicially created doctrine against corporate practice of medicine, then the legislature would be free to debate and decide on those policies, right?
If you didn't have the corporate practice of medicine, the legislature could subsequently expand the jurisdiction of
Yeah, they
the
could do
Board of
whatever they
Healing Arts.
wanted. I mean, presumably within constitutional limits.
Yeah, absolutely, they could have. Just like they could have abolished the doctrine.
And that's my
subsequent-
question really is where is this policy debate more properly located? I mean, should a court-made doctrine sort of short circuit that full public policy debate in the legislature?
Well, I think the public policy debate has been had, which is why we see the creation of the Professional Corporation Act and the Kansas Healing Arts Act, which were developed subsequent to this court's adoption of the prohibition. The legislatures addressed it. And between the Professional Corporation Act and the Kansas Healing Arts Act, coupled with the common law doctrine, they've got everything covered. But when you have a general corporation practicing, that's when we have a gap in the regulatory scheme.
That's where the common law has been taking care of it up till now.
Correct. Correct. I want to give my colleague time as well, but answer any additional questions or upon rebuttal. Thank you.
Thank you, counsel.
May it please the court, Stephen Netherton on behalf of Dr. Hadasol, and I would also like to reserve half of the 3 minutes for rebuttal, Your Honor. I would like to go back to Justice Stiegel's point about where the doctrine originated, and originated in common law to address a public policy issue, as have other doctrines to enforce certain business transactions, one even that's present here, enforcing non-compete covenants. And the boundaries around permissible non-compete covenants is another doctrine found in common law that draws boundaries around what kind of non-compete covenants are permissible.
That falls within one of our sort of traditional slices of the common law, contract law. But regulation, I mean, do you agree or disagree that regulation of an occupation doesn't really fall into the traditional ambit of common law, does it?
My view, Your Honor, is they both stem from the same thing, and that is public policy. Here, the public policy being the provision of medical services by licensed or unlicensed individuals or entities in Kansas and many other states has been prohibited against corporations, with the exception of, in Kansas, hospitals. And here, in this case, the problem arose when an entity that is a corporation, structured as a corporation, ceased existing as a hospital, relinquished its hospital license, thereafter employed Dr. Hadasol to provide family medicine services at that time at a clinic that was off-site from its main facility. And in all ways, that entity really continued to act like a hospital when it no longer held a hospital license.
Counsel, I have a couple of questions based on the court's journal entry of judgment, the district court's journal entry. Was the we've got the contract here. It's dated July 30, 2012. Was there any gap of time between when this was signed and when your client started to work?
I'm sorry, I'm misunderstanding the...
Was the contract signed very long before your guy started to work in Great Bend? I couldn't find, I don't look deep, but I don't have it right near me.
And truthfully, Your Honor, I could not tell you exactly with specificity to answer your question what the dates of time were between the start date in the clinic versus the time of the execution of the document. It sounds like that's what your question is asking for.
That's what I'm asking. Okay, so now I'm looking at paragraph 10 of the journal entry. It says, beginning in January of 2013, your client became a member of the ambulatory surgical center by virtue of having privileges. Is that date accurate? You don't have that, and it's not controverted, is it?
I don't believe it is, Your Honor.
Okay.
I don't believe it is.
And then the end of that paragraph, it says that your client didn't recall ever using the privileges. Now, there's probably no dispute about what he remembers or not, but is it controverted whether he ever used the privileges?
I'm trying to think about whether the plaintiff at that point controverted that. They asserted that the privileges did exist. I do not recall them controverting that fact about the exercising those privileges. And for clarification, the privileges we're talking about were privileges to perform pre-surgical evaluations of patients in connection with the ASC. Now remember though, that what is the issue in this case is the contract for Dr. Hadasol to provide family medicine services for CKMC and the post-employment covenant to the non-compete covenant when he decided after his contract expired to provide family medicine services elsewhere. I only mention that because it doesn't seem to bear much on that issue what his particular privileges were as relates to the ASC and whether he exercised those privileges. What he was ultimately sued for was practicing family medicine services elsewhere
For a
after his
competitor,
contract expired.
across the street.
Across the street, exactly, Your Honor. And that point is not controverted.
It's a non-compete enforcement action with a snag.
Sorry?
This is a non-compete enforcement action with a snag.
With a snag, yes, Your Honor. And if I may conclude, Your Honor, I see I'm out of time, but if it,
I'll grant you 60 seconds.
Thank you, Your Honor.
Enough time?
what really happens in this case is that this was a problem, as I said, of CKMC's own doing when they relinquished their hospital license but continued to practice as a hospital. Hospitals can, under 65-425A, operate clinics, family medicine clinics being one of them. CKMC could have avoided this problem altogether by two avenues. One, they could have taken, after they relinquished their hospital license, they could have taken their family medicine clinic where they were employing Dr. Hadasal and structured it separately as its own professional LLC or professional association where there is no problem with the corporate practice of medicine doctrine whatsoever, and then move forward with the ASC and other divisions on the one hand, and then this clinic with Dr. Hadasal being employed on the other hand. Or what they could have done, in light of the Early Detection Center versus Wilson case, seeing that that was on the books, and knowing that they were a corporation and they had just relinquished their hospital license, CKMC could have reorganized as a professional LLC or professional association, and that would have helped them avoid a lot of these problems. But we're here today because of choices that were made regarding this professional organization's structure, but in light of the court's precedent in Early Detection Center and in St. Francis, and no case has been brought forward by the plaintiff showing that ambulatory surgical centers that are corporately owned are exempt from the corporate practice of medicine anywhere, including in Kansas. The non-compete provisions here are void.
But nobody saw fit to challenge them until there was a lawsuit over a non-compete.
Beg your pardon?
But nobody saw fit to challenge the setup until there was a lawsuit over the non-compete.
That's how precedent is set.
Kind of a gotcha. Yeah, okay.
Any further questions? Thank you, counsel.
May it please the court, opposing counsel. My name is Sam Blatnick. I represent Central Kansas Medical Center, doing business as St. Rose Ambulatory and Surgery Center. There is a structure in place, a highly regulated structure in place for entities and facilities that operate ambulatory surgical centers. Chapter 65, Public Health Act in Kansas, requires entities seeking to operate a medical care facility, including an ambulatory surgical center, to apply for and receive a license. That statute then defers regulatory power over both those facilities and applicants to the Kansas Department of Health. Specifically, Chapter 65, 429 provides that the applicant and the physical facilities of the medical care facility must meet the requirements under this act. In this instance, as early as January of 2011, 3.5 months before the entity at issue here went from being a hospital to an ambulatory surgical center, Central Kansas Medical Center was in discussions with the Kansas Department of Health. The Kansas Department of Health was fully aware of exactly what Central Kansas Medical Center wished and intended to do. The Kansas Department of Health blessed the structure at issue by issuing the license. It blessed the structure at issue thereafter each year.
Well, KDH&E can't change the statutory definition of an ambulatory surgical center, can it?
No, it can't, but it is entrusted with, under Chapter 65, of enforcing and imposing the statute, and then the regulations.
We don't defer to the agency's interpretation of the statute, do we?
No, you do not defer. Well, you defer under operative construction to its application of the statute, not the legality of construction of the statute itself. And here, the interpretation of the statute that the Kansas Department of Health undertook was to analyze the structure at issue and to bless it.
But we don't owe any deference to that blessing, do
No,
we?
you review the ultimate legal decision de novo.
So how is it that the family practice clinic fits the definition of an ambulatory surgical center under 425F.
But it doesn't, but this is where there is a disconnect here. Dr. Hadasol, pursuant to the employment agreement at issue, applied for and received medical staff privileges. He was part of the medical staff of the surgical center by virtue of his family medicine specialty. That is what he put on his application. Thereafter, the record is undisputed that he performed pre-anesthetic consultations of patients that received surgery in the surgical center.
Let me
He was
stop you there.
authorized to do so. He had privileges to do
No,
so.
he actually testified that he did in fact he analyzed patients for anesthetic preoperative reasons. He did not actually perform any surgical procedure. He said he did some small laceration repairs, if memory serves.
Okay, counsel, when my question to your colleague, opposing colleague, about paragraph 10, do you controvert then the district court's finding in the summary judgment order that says that the doctor did, he says it does not recall ever using the privileges. I don't care what he remembers or not, but do you controvert that he used those privileges?
My recollection of Dr. Hadasol's testimony was that he did in fact give preoperative anesthetic analysis to patients receiving surgical care in the surgery center. And he did so by virtue of his member of the medical staff of the surgical center.
Okay, let me ask you just a couple other questions about this summary judgment order. Paragraph 8 says that the license for operating the ASC was issued to CKMC. Is that correct?
CKMC doing business as St.
I don't
Roach.
care about the doing business part. The license goes to this general corporation, Central Kansas.
The license goes to a corporation and a facility that is then licensed.
Right. I understand that you've got a facility license, but the holder of the license is Central Kansas.
Yes.
Okay.
And by virtue of holding that license, it becomes a medical care facility and a healthcare provider under Kansas law. And we believe, therefore, St. Francis applies, and specifically this court's previous statement that the hospital at issue there was both a healthcare provider and medical care facility, and that distinction was crucial in the court's determination in the St. Francis decision.
So when the contract was entered into on July 30th, 2012, and he's not associated with, according to the district court, he's not associated with the ambulatory surgical center until January of 2013. That's when he gets his privileges over there. How is this contract not void when it's entered?
Well, the contract does not provide that Dr. Hadasol will not work in the surgical center. The contract says he's going to provide family medical services or other services customarily provided by similar physicians, and it says he's going to work at the Joe's Clinic or elsewhere as agreed between the parties.
But he didn't do that.
No, but he could have. On day one, Dr. Hadasol could have gone right to the surgical center. That isn't what happened under the facts here, but that could have happened. And for the agreement to be illegal, it has to require illegal conduct. So in the present instance,
Isn't the provision of family medical services illegal conduct?
No.
It sounded like you admitted that.
family medicine doctors in the state of Kansas do surgery. Family medicine doctors do a whole range of things. And Dr. Hadasol actually applied for surgical privileges in the ambulatory surgical center.
Are you saying that nothing that he did was unlicensed? Because I heard you say earlier that you were essentially conceding that the clinic did not fall under the ambit of the ASC license.
It does. If I said that, I misspoke. It does.
Well, let me get back to that question, because I think the question I asked was, how is it that the clinic falls under the definition of an ambulatory surgical center under 425F?
Well, because under KSA 65-429, in issuing the license, the Kansas Department of Health is empowered to review and analyze both the applicant and the facility.
We already established that we aren't going to defer to KDH&E's determination. I'm looking at the statutory definition.
The statutory definition
which requires
facilities.
A facility that's equipped and operated primarily for the purpose of performing surgical procedures.
Yes, and those facilities include buildings, equipment, and the medical staff, including physicians.
So how
and
was the
practitioners.
family practice clinic equipped and operated primarily for the purpose of performing surgical
The family medicine
procedures?
clinic was not part of the facilities as the definition of the.
Okay, so it was unlicensed then.
The clinic itself was not, but the entity operating it was. And
But
paid
the
into-
license that the entity operating it held was not broad enough in scope to cover the services offered through the family practice clinic.
Yes and no. Dr. Hadisol, as a family medicine practitioner across the street, could go over and do pre-anesthetic consulting services to the ASC. So as an individual, he could be part of that, even though the physical location across the street wasn't. And in fact,
Including the things he did in that physical location.
yes.
Okay.
And in fact, the pre-anesthetic consultations that Dr. Hadisol gave are required under the Kansas regulations for ambulatory surgical centers.
It makes it, maybe I just don't understand this, but it makes it sound, you make it sound like it's legal for Central Kansas Medical to contract with a doctor, put in the contract that we might send you over to an ambulatory surgical center, but we don't have to, and then have them work somewhere else that's not associated with the ambulatory surgical center all day and all night, and that's legal under the this common law doctrine.
I'm sorry, legal or under the common law doctrine articulated by the appellate court or the previous common law doctrine?
The previous common law doctrine, before it was expanded.
Under St. Francis, if the entity at issue is a healthcare provider and or medical care facility, then yes, I believe it would be. As opposed to, for example, Early Detection Center, which was a non-licensed, non-regulated, single-purpose, non-invasive vascular testing center.
Isn't it more accurate or maybe more precise to say that St. Francis's holding was that when a corporate entity has its own license, that services offered pursuant to that license do not violate the common law ban on corporate practice of medicine? So the question then is, did these services fall within the ambit of the license that your client actually held?
Dr. Hadisol did in fact perform services pursuant to the employment agreement that fell within that ambit.
And he also performed services that fell outside that license.
Yes, he did.
So are you breaking the law when he's performing services outside of the ambulatory surgical center?
I don't believe
Is it enough
because
to bless this agreement because they stepped foot occasionally in the ambulatory surgical center? And is this then a fact-intensive discussion?
The policy concerns that underlie this doctrine are concern the imputation of corporate motives upon physicians such that they will not carry their duties in the manner in which they are entrusted and are supposed to do. And I would posit that by virtue of the entity itself being regulated, the entity paying into the Healthcare Stabilization Fund, and having to proffer its proof of insurance, for example, to the KDHA under the statute at issue here, that the concerns are not implicated because what you have is an entity that is being monitored, an entity that is being controlled, an entity that is paying into the Healthcare Stabilization Fund, such that the concerns of a lack of patient care or miscare are not implicated. And in fact, Dr. Hadisol had every opportunity to testify in this case that the corporate structure here, the corporate structure being a non-for-profit run by the Catholic Health Initiatives, somehow improperly impacted his decision-making or his motives or any other part of his practice.
Counsel, along
And he did not.
those policy lines, would you agree that if the state of Kansas did not have a common law corporate practice of medicine doctrine, that would resolve all of this and that you would walk away with a valid contract?
Yes, Justice Steele. And in fact, going back to a question that you asked earlier today, states are all over the board on the corporate practice of medicine doctrine. It is a very unique doctrine where it exists and that embodies the policy and concerns of each state. Many states do have statutes. The Kansas legislature has had the opportunity to pass one if it felt it was necessary, and it has not done so.
And since we have it, you're trying to fit your argument into St. Francis Regional Medical Center.
We believe that the language used by this court in that decision applies here. This and this is where there's a fundamental distinction between my client and the appellants. The court in St. Francis said that they declined to extend the facts of Early Detection Center. And you've got to look at this in context. Early Detection Center was entered in 1991. The previous case, the Zales jewelry case, was 1956. So we have a 4-decade lapse. And a lot changed in that period of time, obviously, in the practice of medicine. And Early Detection Center was not an optometrist trying to sell glasses like Goldman and Zales. It was not a dentist in the back of a building. It was a single-purpose entity. And in Early Detection Center, the court said that this is a general corporation because it doesn't pay into the Healthcare Stabilization Fund, and it doesn't do so because it's not a healthcare provider. That's not the facts here. Fast forward to 1994 in St. Francis. This court said we declined to extend the holding in Early Detection Center. So that's where we're coming from, is that Early Detection Center itself is an outlier, not this general umbrella. And the facts here are certainly distinguishable from those in Early Detection Center, where we had a single-purpose, for-profit entity. We have a general-purpose healthcare provider that provides all services other than overnight stays and ambulatory care, emergency care, I apologize, and wanted to close down and tried to close down. This structure was born out of a compromise to provide healthcare, to provide as much healthcare as could be provided in the state. And that's why, I made this argument at the appellate level, a ruling that the structure such as this is not legal, a ruling that the blessing of the regulatory body at issue here is not legal, is going to limit healthcare in the state. And I understand the importance of making sure that the healthcare that is provided is good and the motives underlying it are proper. But as we see here, under the structure issue here, those concerns weren't implicated. They just weren't.
Do you think we have a controverted fact that needs to be resolved about whether the doctor actually used the privileges at the ambulatory surgical center?
Having deposed Dr. Hadasol and having cross-examined him at trial, it's my recollection, and quite clearly, that he did in fact. And if the record is,
all I can do is deal with the district court
then-
order here, and
then
I'm
yes,
trying to see whether that isn't a material fact as to whether your contract is good or not, whether he was actually doing, in my mind, a material or significant amount of work for the ambulatory center.
if that is, I believe, a material fact in this case. And it's a material fact because if you look at St. Francis, this court said to hold that the contracted issue was invalid there would prevent hospitals from doing what they've done for years and what they need to do. That's the same here. Dr. Hadasol was employed to provide required services.
Let me tell you what I'm struggling with. It seems like it wouldn't be a material fact if your earlier answer to me was right, that it doesn't matter whether the doctor is working a little bit in the surgical center or a whole lot in the surgical center, as long as you put in your contract that he can walk over there and work whenever you want him to. You see what I'm getting at?
No, I understand what you're saying. I also understand the concerns that you're implicating. But I think the baseline we have to start from is that if you are an entity that has an ambulatory surgical center and you're offering other clinics, there is a possibility that those doctors may provide treatment in that ambulatory surgical center. For candidly, any of the remaining clinics. Just because by virtue of surgery, a surgeon requires and calls upon other practitioners, both physicians and physician's assistants and the like.
Counsel, I see you're out of time. We've taken up a lot of your time with questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
I would take the 30 seconds, Chief Justice Ness. In this particular instance, we have a doctor who, for only purposes of trying to invalidate a non-compete, he has not reported himself to the Kansas Department of Healing Arts, claims that he engaged in the improper and unlawful practice of medicine for several years. In Weber v. Tillman, this court cautioned against seeking loopholes to invalidate contracts. That is exactly what the appellants are trying to do here. Having received compensation from St. Rose, having received patients from St. Rose, having received training from St. Rose, and having on the way out misappropriated confidential information from St. Rose, Dr. Hattasol went across the street to its primary competitor, while his wife also was involved in that as an employee of St. Rose still, and now seeks to find loopholes to invalidate an agreement that for years he recognized as valid, and again, solely for purposes of this litigation.
Thank you,
Thank you.
counsel. My understanding is you are splitting your 3 minutes.
Yes, Chief Justice, that's my hope or intention at least. Thank you. I just want to address any questions the court have, but barring that, 2 points. I think the argument that opposing counsel is making is he's trying to place all medical care facilities on equal footing, and I think the point Justice Stegall raised is that that's really not correct. Under 65-425, a medical care facility is only defined by its constituent parts: a hospital, an ambulatory surgery center, or a recuperation center. That same statute then defines each of those facilities. It has a definition of a hospital, which says that it can be organized to have physicians 24/7 to treat a wide variety of conditions. In contrast, subsection F defines an ambulatory surgical center in a much more limited fashion, and to that extent, they don't all stand on equal footing. And
In fact, the licenses the entities get are different.
absolutely,
They're licensed under the narrower portions of the statute, not under the broader portion of the statute.
that is correct. That is correct as well. And to that extent, to try and extrapolate them all on equal footing fails to give meaning to the legislative definitions under KSA 65-425. Also, to the point of the controverted fact, my recollection of the record is proposed findings of fact were submitted to the district court. I don't recall an objection to the factual basis in the questions that Justice Biles was asking earlier. And to the extent, even if he pulled some stitches out or on a rare occasion was at the ASC, our position is that's the scope of the protectable interest of the non-compete and not the prohibited portions under the corporate practice of medicine doctrine. And he left employment to practice at a family clinic, which I would argue that it's not a material fact to resolving and reinstating the district court order in this case. Barring any questions, I will rest on that in the briefs. Thank you.
Any questions? Thank you, counsel.
I only have two, obviously very brief points to make. Point number one, I think should be made is the issue of whether to overturn the corporate practice of medicine doctrine is not before the court in this action. It was not requested by the appellant. In 1994 in St. Francis versus Weiss, the court could have overturned it, looked at case law from New York, Missouri, Nebraska, and Florida, and statutes from those states, and then also considered amicus briefs and chose not to overturn it. That issue has not been before the court in this matter. The second issue I want to address is to Justice Biles' point about whether there were pre-surgical evaluations actually performed. The citation to the record about that testimony, Your Honor, is on volume 16, starting at page 120, volume 14, starting at page 87. No, there's no evidence that Dr. Hattasol ever performed such evaluations pursuant to those pre-surgical privileges. Unless there are any questions from the court, we request that the court reverse the Court of Appeals decision, reinstate the district court's entry of summary judgment.
Do we have any questions? Thank you, counsel.
Thank you.
We thank all three lawyers for your arguments this morning and this afternoon. The court will take this matter under advisement. That